me and my colleague, unfortunately, were surrounded by the said police and they snatched my phone. Snatching my phone was something which I had never experienced. They're going to do it for a lawyer. The moment we gave the contact number, they started telling what car I drive, how much money I have in my bank account.
My decisions are not my decisions. My decisions are taken by somebody else. Maybe we have consented to be profiled. Whatever exercise of power that was subject to constitutional limits in the physical world, the same limits should be available even in digital world. Liberty is very, very precious. Whether he is coming from judicial custody or police custody or prison, it makes no difference. You are jailed for 1 day.
It leaves a permanent scar on his right to privacy. Is it really there anymore with this digital era? How the constitutional debates happened? Are we?
See, that is so beautiful and dangerous a transition that is happening. Okay? This is a world of cognitive subservience. My decisions are not my decisions. My decisions are taken by somebody else. I take decisions based on the information that is fed to me. Okay, the market forces are in operation. Corporate giants are in operations. They are all influencing my decisions of my children, decisions of my spouse, everyone. We have surrendered ourselves to information. I have bought this cell phone because somebody wanted to sell it. I have bought that laptop because somebody wanted to. I have bought this coat because somebody wanted to sell it. Okay, that brand. They know they are the man. But the problem is, are we free to think in this country? That's why there is an argument that is going on that whether cognitive autonomy should be a fundamental right in this country. Because all these pop-ups, targeted advertisements, say in elections also, fence sitters, that swing happens because of the type of material that is posted to them. So elections also can be tilted through media.
In fact, Donald Trump won because he came up on podcast, the Joe Rogan podcast, some 3 to 4 podcasts he came together just before the US election were about to happen. And finally he won. I mean, this major spike happened when he was tried to kill. But regardless, you are right. Like, because we are basically going with the algorithm. You like some 5 to 6 posts about, let's say, BJP. From next day onwards, your post will be related to BJP. You like something about the Congress or opposition, for next 4 to 5 days, your feed will be full of this thing.
See, this is the problem. This is another question.
Yes.
Have I consented to be profiled? Should there be a right against being profiled? So when I get it on what is this, Facebook, 1 year back you posted this, 2 years, he goes up to 15 years and sends it back to me. So initially I was feeling back. After 1 month, he gives me the map of, you had gone to Nagpur, from Nagpur you went to Delhi, from Delhi to here. I was getting fascinated initially, but later why this fellow is following me wherever I go? I have forgotten, but he remembers.
Yeah.
What I posted 15 years back, I have forgotten.
Yes.
He remembers. And in this, there is a photograph, there is a camera. You click the camera, it will note down the date and the place where you have clicked that picture. Have I consented to all these things? Okay? But consent is a very, very intricate thing. There is what is known as layering of the consents. If you go through Justice Sri Krishna Commission report, he speaks of consent fatigue. So I download something. If I want to use that app further, I have to agree. I have to allow access to camera, allowed access to this, allowed, say, agree, allow. Otherwise, it will not run in my phone. Am I reading? I tell you out of curiosity, Geo News. Okay, Geo, it's a news channel, no? The consent form of Geo News runs into for about 20 pages. Right? One of my PhD students is working in the area, in this area only. So because of guiding that candidate, I have read at least around 40 consent forms. Highly intricately drafted documents, drafted by qualified professionals, hired by these platforms. And I am consenting. One. And second, there is what is known as layering of consents. Okay, I have consented for this, I have consented for this, I have consented for this. When they layer consents over one another, it will derive a consent to which I have not consented. This is called layering of the consents. And maybe we have consented to be profiled. We don't know. This is a very, very complex thing. And here what is happening is, both in professions and also in our lives, this is interfering. Okay. Constitution is supreme. Administration should be conducted. Everything should go on in this country as per the Constitution. We call it constitutionalism. There should be a constitutional culture that should be built and, say, inherited from generation to generation, because the nation is important, because we can sit here and speak because that Constitution is there.
Because the reason the question came up, sir, I wanted to I have already explained what has happened, but let me explain the part of it because the matter is still in the subjudicated. Being a lawyer, I was representing my client in a different state, and around because they had taken my client away without producing them to the nearest judiciary within 24 hours. It's already been 10 plus days, and we were asking to whereabouts of the client. Being the officer of this court, being the officer of the court, being the attorney, I was called to the nearest district commissioner of police station around 11:30. Me and my colleague, unfortunately, were surrounded by the said police, and they snatched my phone. The police threat to the lawyers, it happens. But snatching my phone was something which I had never experienced. They're going to do it for a lawyer. They did it. After doing it, what amazed me more was that they asked for me and my colleague's contact number. We gave our contact number. The moment we gave the contact number, they started telling what car I drive, how much money I have in my bank account.
Yes.
They were giving A to Z exact details. So that's where I got scared as to right to privacy, the fundamental right. Is it really there anymore with this digital era?
Correct. So what is happening is, initially we were talking about constitutionalism, everything according to the Constitution. Okay? From constitutionalism, we moved to, positive constitutionalism, negative constitutionalism.
Yes.
Okay? Then transformative constitutionalism. Right now, we are speaking in terms of digital constitutionalism. Okay?
Yes.
Why we have to speak in terms of digital constitutionalism is because state is using digital world for its purposes, for investigation, for direct benefit transfers, for veritable number of, for property registration, for veritable things. State is using technology. Digital world state has entered into. And along with state, there are other power players also, like market and other things. They are also in the digital world. So whatever exercise of power that was subject to constitutional limits in the physical world, the same limits should be available even in digital world. That is digital constitutionalism. Maybe it is just a matter of few years, wherein the principles of accountability, everything will come in this place also, when state is using it for the purpose of investigation, for any other purposes, they have to follow due process. There is no way. But to that, state is to be sensitized and the machinery of the state is to be sensitized. Okay, these are the principles in offing. Unfortunately, you read in the newspaper, no, there was one Krish who is a digital fraud who is in the police custody. So to break certain of the, to have breaks in investigation, they take him for the purpose of assistance.
Yeah.
Right? It appeared in the newspaper, no?
Yes.
Huh?
I read it, yeah.
So
They're taking his help.
you have an accused person who is far, far superior than our investigation wing. So we take his assistance. So we have to equip ourselves for this. And all this is to be tempered with constitutional norms. There is no escape. Right now, because we are in a flux, things may not be happening. But for the for instances that you explained, there should evolve norms. And here and there, by now, Supreme Court has issued guidelines about use of AI in the legal profession. Right? So like this, things will start. And your own Bar Association, Bar Council has issued a circular that lawyers, while making reels and other
Yes, they
things,
can't
there
do
should
it.
be some deterrence.
They can't, I mean, like, yeah, I agree. Doing reels in the court, it's like
Police
serious.
people have issued a circular that in police uniform,
Yeah,
they should not do all these things. But you have touched upon a very, very important. So when we have moved majority of our transactions from the physical world to virtual world, that world also should be governed. Even if it is a corporate entity, see, as certain of our rights are available against the private individuals also, which are fundamental rights, against the corporate giants also these rights should be available. And sometimes it is very disturbing. When the government of India decides that in all the mobiles manufactured in India, Sanchar Sati app is to be pre-installed. Within 2 days, they rolled back that policy because some of these very big firms, they said, we will go out of India. We
Yeah.
will not manufacture things here. So these are the people who have ability to influence the policy decisions, but state has to exercise its power. So now installing Sanchar Sati has become optional. People who want, they may install. And you have that competition commission decision imposing 2 point so many lakh crores on Meta for that consent form, take it or leave it form on WhatsApp. So things are happening. The institutions are asserting. State is also slowly flexing its muscles to govern this area. It may take little time, but already, see, in Europe, we have GDPR rules in place. And here we have DPDP Act and DPDP rules. Things are happening slowly, but gradually they may get strengthened. And that sphere also is to be brought under constitutional governance, digital constitutionalism. Yeah.
So you have been a constitutional man, sir. What you used to teach, the evolution, you have literally evolved 37 years of experience of teaching. Then you came to the framing of the law aspects of it. So when it comes to the framing of the law, because you are in the kill power right now, when it comes to the framing of the law, what happens behind that closed door as to because whatever the law which you frame and which will be implemented, if it questioned in the court of law, it has to pass certain parameters. So if it doesn't pass that parameters, whatever the effort which has went through passing that law or is drafting that law will be a waste of time. So what are those sensitive things which people or else a law student, a law profession overlook, but you can't do that?
See, this is a very, say, sensitive and very technical exercise. Technical in the field of law. So many beautiful things happen, right? I am an academician. Academician has unlimited choice of reading things. And the whole life he keeps on reading from this country, this country, this country. Okay. And nobody can claim monopoly over any subject or
Yeah, that's true.
any
That's true.
discipline. It is a process. All of us are students. Jamshedji Kangai, at the age of 90, he said he is a student of law. And after that, everyone has started calling themselves, even Chief Justices call themselves students of law. So I am also a student of law. And incidentally, constitutional law. See, I tell you how things happen, beautiful things happen. When Sri H.K. Patil became the law minister in 2005, he called academicians. He has his own style of functioning. He called academicians, NGOs, practicing advocates, all of them had a sort of brainstorming session to frame the policy document for the law minister then in 2005. So when we were framing
2005 this was.
2005,
Okay.
I am saying. When we were doing this, I made an observation because I had made a study. Then I said, sir, under Section 30 of the Protection of Human Rights Act, 1993, there is a provision to designate human rights courts, establish human rights courts. But till today, no state in India has done this. If you do it, Karnataka will be the first state. You will have the credit. Then he asked the law secretary to check whether what Principal C.S. Patil says is right. Next day, Principal Secretary Law Department, he said, what professor says is a fact. There is a provision, but nobody has done anything about it. Then what is the provision? The state government, in consultation with the Chief Justice, may designate a district court as a human rights court. No expenditure is involved, no manpower is involved, nothing is simple as simple as. Sir, you have to believe the Honorable Minister took interest. He walked across to the High Court, took the appointment of the Chief Justice, met him, took his consent and designated the Principal District Judge as the human rights courts in Karnataka for the first time. 2005. After more than 10 years of the Protection of Human Rights Act, we conduct human rights seminars, conferences, we speak of human rights. This is what that happened. Then after a few months, he asked me how human rights courts are functioning. And I said, sir, we have not framed the rules for that. Who has to frame the rules? You have to state has to frame the rules. Then he said, start drafting. We drafted human rights courts rules. Okay, the fundamental question was whether state has power to make these rules. Whether state has power to make these rules, there is that section of delegation of power to make rules, no. So I was relying upon that and arguing. But all the bureaucracy was of the opinion that state has no power to make rules. I was of the strong conviction that state has power to make rules. Then Honorable Minister said, see, you are the only person who says we have the power, but nobody is supporting you. Then I said, sir, this is my understanding. Then we went to different people, and that is a long story to be cut short. Ultimately, I could convince the minister. Minister said, give me some strong reasons as to why you say we have power to make. Sir, it is like this. When the Constitution was enacted, there was no provision to reserve seats in the educational institutions for scheduled caste, scheduled tribes, backward and other things. Madras government went ahead and issued a order which is known as Communal Government Order. They have no power, but they made. That was challenged. In Champakam Dorarajan case, it was challenged and it was struck down. So a provision which was made for the benefit of the backward people was struck down by the court because they had to go by the Constitution. Then what happened? Constitution was amended. made provision for the education of these people. No? So we will make rules. If it is struck down, there will be some change in the law itself. If it is upheld, okay, that is for the cause of serving the human rights. So in a bold step, he took it to the cabinet, got it approved and notified. So that's how Karnataka becomes the first state to have designated human rights courts. Human rights courts rules were gazetted in 2006. Okay. Now, as a professional, you can check how many states have designated human rights courts in this country from 1993. See, this is how it happens. And now, when we sit to draft legislations, we constitute different teams, a cross section of the people, different inputs. And first thing we check is competence, whether state is competent. So, as per the entries in the schedule, whether this comes within the entry of the state. That is one thing that is to be checked. And second, the point that you rightly touched upon, other question which will be very carefully considered is every clause will be scrutinized to check whether it can withstand the constitutional scrutiny when challenged before the court of law. That's what we check. And then financial component is very important.
Yeah.
How much of financial burden this law will exert on the state. State will take a call on that. See, if certain of the good things can be done without additional budgetary burdens, why not do it? If it can change the system for the good of the people. So that is one thing that we can finance aspect. And sometimes what happens is, if you put so many things in law, it may get stalled. So sometimes it may be good to be practical than being ideological. Okay, start with this and later you can go there. See, when you have to introduce things which are not heard of, so slowly you have to introduce and get going. So like this, there are veritable things that will be taken into consideration when laws are drafted. And the basic thing that is borne in mind is good of the common man and respect for the constitutional values, liberty of the individuals. There are veritable unused concepts. See, for example, you appreciate that in the new BNS, community service is introduced as a form of punishment. Okay?
Yes.
The definition of what is community service is to be found in BNSS. Right. I feel, see, community service comes after conviction. Right? And that column comes in the application when I apply for a post, job, where you convicted of any offense. Right?
Yeah, that's right.
I have to say yes.
Yes.
There is one fascinating concept known as expiative punishment. This is used in plea bargaining in some of the countries. We are not using it both under BNSS plea bargaining, earlier CRPC plea bargaining, we have not used it.
Okay.
So expiative punishment is, once you punish a person, maybe sentence of imprisonment for a month or whatever it is, maybe admonition, maybe. After he serves that punishment, his slate will become clean. As good as not convicted. Okay. So if the punishment is made expiative, then in that column where you convicted, he can comfortably say no. Because the punishment is expiative punishment. Expiative punishment is, you will not carry the guilt of being punished. That stigma, not guilt. Stigma of being punished will not be attaching to the person for once for all. So ideas are there. They can be pressed into service. Any research institute like my institute or any research university, see, it should be a crucible of ideas, right? See, we should not start in thinking in terms of solutions when the problems arise. Like as we grappled to invent vaccine when epidemic broke out, coronavirus broke out, right? Research institutions should keep ideas, concepts ready. When the time comes, that concept can be pressed into service. Okay, so these research institutions should be crucibles of ideas, crucibles of look around, make a comparative study. What we can borrow, what we can press into service, what innovative steps we have to initiate, which are customized for our purposes, for our population. So this is what that should be going on in a research institute. They are very, very wonderful formulae. When we look into different systems, there is something to learn from every system, especially continent. Okay?
Like when, yes, sir.
See, for example, there is a concept, restorative justice. Okay. Howard Zarr is an author who has written a little book on restorative justice. It's very fascinating. Restorative justice, what is this? See, I read in the newspaper that a victim of rape, a girl, is thrown out of the school because she is victim of rape.
Victim blaming.
She is a victim. She is not the culprit. But that school does not want a rape victim in that school. Okay. And parents look down upon a raped daughter. Neighborhood will look down upon that victim. See, restorative justice will involve not just payment of compensation to the victim or just imprisonment for the culprit. It will involve appropriate counseling of the school, classmates, neighborhood, parents, everyone to receive this as a victim with all respect than treating her as a culprit. Former suicide, accident, whatever, some compensation is awarded. Earning member is gone. How the family moves without that earning member, you have to concentrate. See, restorative justice will bother about all these things. But our civil justice, criminal justice, we are bothered about compensation, we are bothered about imprisonment. Later what happens? Somewhere in the appropriate legislations, we have to try some elements of restorative justice. Things are there.
So you actually touched upon the right topic, sir. Like when we compare the criminal law, the criminal justice system to the Indian and the America, I see a vast comparison over there. The first topic is that the doctrine of the fruit of the poisonous tree. In America, if the police secures any proof through an illegal way, that document won't be admissible in the court of law in America. But in India, that's the other way around. The justice system says, even if you acquire certain documents through the illegal way, I have to make sure that I meet the end of the justice. I will take into the consideration. My question is that the moment the court accepts that kind of a documents which was acquired through an illegal means, the basic structure of the doctrine or else the basic fundamental rights, the rights of an arrested person, why should the police follow it? Let's say the police will arrest a person illegally, detain him illegally, and the trial will start. I feel the moment they acquire documents illegally, keep him illegally, the trial shouldn't go at all. Because if not, what are we upholding the constitution? Don't you think we are letting go of the constitution in one way to meet the justice in another way? Are we in a mixture of not sure what is right and what is wrong as to why the doctrine of the fruit of poisonous tree is allowed in India?
See, it is like this. In our earlier Evidence Act and the present Saksha Adhiniyam, we have this chapter of relevance of facts. Okay? There are certain sections which speak about what is relevant. Okay? whatever evidence that is collected through investigation, whatever, unless the advocate is skilled enough to prove its relevance, it will stay out of court. It cannot come onto the record. Therein they speak of excluded evidence. Here we speak of relevant evidence. That is the difference in the basic principle that we follow in general. But see, as we progressed, the legislations have changed because of the modern crimes. There is shifting of burden of proof. Okay, in all special laws like NDPS Act, illicit traffic in NDPS Act, Railway Property Unlawful Possession Act, all these terrorism related legislations, organized crime legislation, COCA,
Where the accused has to
NCOPA,
prove as to why I should.
quota,
Yeah.
burden of proof is shifted. Once certain of the facts are brought on record, on the basis of those facts, there will be a presumption that so and so has committed that offense, and the burden of proof is on him to prove that he has not committed crime. Here the fundamental question arises when it is so difficult for the state with all that power of investigation, search, seizure, interrogation and all things, when you find it so difficult to discharge the burden of proof, when you conveniently shift it to the accused, in a country which boasts of due process of law, which is on par with the American due process clause of 5th and 14th Amendment, after Maneka Gandhi, we say we are equal to American due process. How you justify this? And courts have upheld the constitutional validity of even PMLA, so many legislations relating to organized crimes, terrorism, etc. See, liberty is very, very important. Okay? That basic presumption that 100 criminals go escape, not even a single innocent should be convicted. The protection of innocence, that is rightly so. But guilty is to be punished. But in the anxiety of punishing the guilty only, we are allowing criminals to escape. A thinker by name Benjamin Franklin, somewhere he makes an observation which will have more bad effect on the society. Whether a wrong conviction will be disastrous to the society or a wrong acquittal will be dangerous to the society. So, if we are allowing 100 criminals to escape in the anxiety of protecting innocent, or shall we run the risk of conviction of an innocent also because of the stringent laws, which will have more bad repercussions on the society? Viewed from the angle of society will be different, but viewed from the angle of the individual's liberty is different.
Yes, the perspective.
Whether society is affected or not, my liberty is gone. No, a wrong conviction because of the stringent laws. If I am incarcerated, see, under PMLA, we find people incarcerated without trial for 6 months, 7 months. And Supreme Court says, when you are not filing even a charge sheet after 6 months, why you have detained this person? Release all those bail important judgments of the last month. This is there. See, gravity of crime. If you go through Justice Malimat Committee report on criminal justice reforms, wherein he advocates that somewhere even preponderance of evidence may be very weak, proof beyond reasonable doubt may be very tough. He speaks of, say, cogent and convincing evidence standards. So, not as stringent as this, not as loose as this. That's one thing. And second, because of these rules of relevance, sometimes we are keeping the best evidence out of court. And the judge decides upon the facts that are there on his table, whatever that is brought on the records. And he goes to the extent of saying that right against self-incrimination is keeping the best source of evidence out of court. Okay. So, see, it all depends upon the policy of the state. Crimes originate in the policy of the state, policy of the government of that moment. Okay. An act which is a crime may be decriminalized. Adultery is decriminalized now. Okay. So, an activity which is a crime may get decriminalized. An activity which is not a crime may get criminalized. It all depends upon the level to which the society disapproves
Yes, it's the evolution.
that activity or approves that activity. And same is the case with the sentence also. The very concept of bringing plea bargaining into our procedure code was that, see, what is plea bargaining? Chapter 21A of the earlier this thing, and now it is a different chapter under BNSS. Plead guilty for some concession. Okay. And what is there in our BNSS is a little improved version of what was there under CRPC. In CRPC, whenever there was minimum sentence provided, if a person pleads guilty, half of the punishment will be given. Whenever there is no minimum punishment provided, then he was provided with 1/4 of the punishment, something like this. And now it is a changed scenario. It is not half of the sentence when it is minimum prescribed for the crime. It is lesser than that. To some extent, that improvement is there. Plea bargaining is a very rich concept. Bargaining with the intervention of the court, bargaining without the intervention. So who are the concerned parties? Prosecution, defense, victim, or any other stakeholders. Okay. These people will be called to sit together and work out a solution. And in our law, we call it mutual satisfactory disposition under our law. Mutually satisfactory disposition. So, prosecution and defense have to sit together and work out. And if the fellow pleads guilty, what punishment will follow is structured in our law. But elsewhere, in Canada, in Australia, in England, America, wherever plea bargaining is pressed into service, there is what is known as charge bargaining. Okay. So, you have charged me with this. I will not plead guilty. You charge me with a lesser one. See, if you are going to prosecute me for this offense, I have this evidence in my favor, I have this document in my favor, definitely I will end up in an acquittal. Why I should plead guilty if this is the charge? Then that fellow says, no, I have this one, then there is a reasonable probability of conviction, etc. So bargain goes on. So he will come down. He will charge me for a lesser offense so that I can plead guilty. See, what happens if somebody pleads guilty? You are saving the judicial time for the appropriate cases. So if there is a contesting case wherein state is sure of conviction, they can devote complete time of the court and the prosecution for that case instead of all these trivialities. If maximum things can go by way of plea bargain. So charge bargaining is there. Then sentence bargaining is there. So I plead guilty for this. What will be the sentence? 3 months, 6 months, only penalty, package, compensation to the victim, bargain for information, bargain not to proceed against the relatives, bargain not to press for other crimes. I tell you, so many typologies are there in the plea bargaining. What we have tried is only very minimum. And in plea bargaining also expiative punishment comes. So the idea is, if we can say properly amend this plea bargaining chapter, providing for sentence bargaining and also charge bargaining, maybe with the intervention of the court also. See, at the core of plea bargaining is there should be factual basis for the court to accept the settlement. There should be factual basis. there is a theme, advantage of being guilty. Sometimes
Okay.
there is advantage in, so as it happens in the traffic crimes. Even if I am not over speeding, if I am stopped and a penalty of 1,500 whatever imposed, I am going to appear before the court and the matter may be called out any time. I will not stand back to fight. I will pay 1,000 rupees, and the importance of being guilty. You will be rewarded for paying penalty because there are various things.
Yes. But when there is a plea bargaining, especially in the Western courts, the final call will be say with the judge, right? Whatever the terms which even the public, I mean, like the government and the said accused have been agreed upon, the judge has to agree for that, right?
What happens is these parties are put together to arrive at a decision. Okay. Unless whatever proposition they have arrived at is to cause the service of justice, it has to serve the cause of justice. Otherwise, that will not be accepted by the court. That's why they should think in terms of factual basis. So, if a wrong person is charged of some of the, he is an innocent person because of various reasons he is pleading guilty, there is no factual basis. Court will not accept if there is no factual basis. There are certain of the underpinnings. But the equation in plea bargaining is like this. Plea bargaining will not be available for all the offences. See, here in our system, plea bargaining is available for those offences which do not carry a punishment of more than 7 years. It is not available for offences against women. It is not available for offences involving socio-economic issues. It is not available against atrocities. See, excluded category will be there. Plea bargaining will be available to the class of offences which are identified there. Grave crimes will not be coming under plea bargaining. All trivial, lesser than this much of sentence. One thing. And what happens with this is, what is happening in plea bargaining? See, there are countries wherein, as far as this class of offences is concerned, 90% of the cases are settled by way of plea bargaining. 90%. What happens when 90% of the cases go by way of plea bargaining is, if we go for 100% full dress trial of all these offences, what happens? What is the rate of acquittal? Right?
Yes.
So the proposition is whether the system should go for a proposition of punishing maximum number of people with a lesser punishment, or take a risk of going for full trial and provide an opportunity for the maximum number of people to escape. Okay. So we are punishing them to a lesser sentence. That is there. But he is saving so much of time, resources for, and this resource, this time can be used to try those cases wherein plea bargaining is not available. They deserve all the attention of the court, no? They deserve all the attention of the prosecution, defense, everyone, no? So if majority of them say it is a bargain, we have to take a chance.
But honestly speaking, the current criminal jurisprudence of India, okay, let me give an example as to where I'm coming from. Recently, I had a case. The person was charged with attempt to murder, 307, now 109 of BNS. I went over there, I was reading through the FIR, the complaint copy, the application which was submitted for the custody of the said person. I was amazed to know there was no grievous injury, not even grievous injury, there was no injury which has happened to the other person, the complainant. But this person, my client, was charged with attempt to murder. I wanted the medical report. How am I going to prove that that person has been injured or something? The medical report. I asked the police, when are we going to get the medical report? He said it will be done during the charge sheet. Until the charge sheet has been filed, I won't be having the access of the medical report. I went to the arguments. I stated the same fact, that there is no grievous injuries which has been happened to the said complainant, but the entire section shouldn't be considered at all. The judge was the first person who asked for the medical report from me was public prosecutor. He was like, sir, where is the medical report? Give me the medical report. I was like, that is your job, right? Judge was asking me the same thing. Where is the medical report to consider that? Give me the medical report. So don't you think, sir, that power which the state or the police has, they can come and charge me with any kind of section, they can take me in. Yes, later on I'll be acquitted, I can get the bail, that process. But even for 5 to 10 days being in a judicial custody, where I wasn't even being able, I mean, like, they can't even charge me with that set sections. Don't you think it's a high time that even though recently the criminal BNS and BNSS was changed, don't you think, like, somewhere we are going wrong as to the parameter as to, do you think, like, it's become like, wherever, whatever the police produce a certain person, the magistrate will order the judicial custody, they will go in.
Yeah.
What do you think, sir? Like, I mean,
It is like this. Let me be very frank.
okay.
I am not a practitioner. I have not practiced law.
Yes.
Whatever experience, it is vicarious experience
The
through
theoretical
friends,
aspect, yeah, I'm asking.
through say judgments and other things. Maybe you also got this forward joke through social media. Cows were running through in the forest, and elephant came from the other side, and it asked, "Why are you so frantically running? Where are you running?" Then that fellow says, "Government is catching buffaloes." See, if they are catching buffaloes, why you are running? You are a cow. Then cow says, "You know I am a cow. I know I am a cow. But the time I prove that I am a cow in the court, it will take long time."
Yes, I know that joke.
Then elephant also started running because the same problem. Yes, that delay is there. The problems are there. See, all this, in my opinion, happens long back. I attended a conference of police officers on the theme Professionalism in Policing. Okay? We lack professionalism.
Yes.
The steward in 5-star hotel is so polished. That's how it becomes. As the professionalism increases, it becomes a star hotel. Right? See, police should become professional. There should be a very strong component in training manual about all these things. See, other day, 1 week back, I went to address the prosecutors in their training in Judicial Academy. I quoted the same statement that is written on Rotunda of Justice Department of US there. I said, look, this is what they have written. That is reproduced in one of the books of Fali Nariman also. As a prosecutor, your business is not to get convictions. You have to appreciate your role. You have to get conviction of the culprits. And equal onerous responsibility is there on you to protect the innocents also. Police is not to, it has to exercise its power. See, there is a concept known as administrative legality, a French concept. That is to be worked out to the maximum. See, it comes under our rule of law. For every executive action taken, there should be a strong basis in any provision of law. Any action taken without a basis in law, he should be personally held responsible. And the Supreme Court and High Courts in different cases have brought in this element of personal responsibility, wherein the courts have directed that the compensation should be recovered from the salary of the concerned wrong police officer and all these things. That jurisprudence has to evolve because liberty is very, very precious. Why 1 week? Even spending few hours in police custody. See, for our society, whether he is coming from judicial custody or police custody or prison, it makes no difference. Yes. They say this fellow has come from the jail. He was jailed for 1 day.
It leaves a permanent scar on his
life.
life.
That is the thing. And see, that is so much of disgrace on the part of the person and also the family. They have to face the society. No, there will be questions asked. So that's why professionalism is very, very important in the police. And that way we should be proud. Karnataka police has a good record. of respecting for human rights and respect for, say, otherwise somewhere else the forces there, as we see through media, they are very aggressive compared to the police people, police personnel in Karnataka. But training is very, very important. Professionalism. See, police should be allowed to do the job of only policing.
But are we becoming a police state?
No, we are a rule of, we are far, far away.
Okay.
We will never ever become a police state
Hmm.
because of that constitution. Such wonderful constitution. The constitutional forefathers have written. No, it is not an ordinary thing. I tell you, any good constitution, we have to remember these things. When see constitution, there is a wonderful book written by Rajiv Dhawan, Constitution of India, Miracle, Surrender, Hope. That is the title of it. He says, the very fact that we have a constitution is a miracle. Who created this miraculous document? Those constitutional forefathers. This Lawrence Tribe has written a book, Reading the Constitution,
Okay.
wherein he says, framing of a constitution is a bold experiment on the part of a nation to create a document which will govern the creator and also all these institutions which it creates. It is binding on the person who creates this. So when all these people come together and write a constitution for their country, they are setting a direction. Okay? And who were the people? Babu Rajendra Prasad as the chairman of the Constituent Assembly. Dr. Baba Saheb Ambedkar, chairman of the drafting committee. Sir B.N. Rao, the constitutional advisor to Constituent Assembly. And it was such great luminaries who were there. I tell you, Mr. Harsha, we have to appreciate what we have inherited through this document. Any good constitution has certain of the principles, yardsticks. A person by name John Burgess has listed the characteristics of a good constitution or a complete constitution. So you have this, no? Park Avenue, the complete man. So if when I put on this Park Avenue, I become complete man. So they say Raymond is the essential thing for becoming a complete man. Like that, for a complete constitution, there are requirements. One, organization of sovereignty, the state, in the constitution. Organization of sovereignty in the constitution. Sovereignty will be organized in the constitution. See, constitution making is not right like drafting any ordinary law. It is a great exercise. It requires experts. When Sir B.N. Rao, who was tipped to become justice in the Kolkata, had he accepted, it is stated he would have become the first Chief Justice of India. But he was invited by the Constituent Assembly, Sir Benegal Narsingh Rao. His brother Shiva Rao also was there in the Constituent Assembly. And his another brother Rama Rao became the first Governor General of RBI. Very, very strong scholarly family from Karnataka. So Sir B.N. Rao, when he was invited, he writes, when we read through Sudish Pai's Legends of Law book, senior advocate Sudish Pai, wonderful book. Therein, when he is invited to become a judge there by the Britishers and to serve the Constituent Assembly here by the countrymen, he has refused the offer of the Britishers and he says, I go with my countrymen because they think that I know something about the making of the Constitution. So he went with the country. Constitution making, now after studying Constitution for so many years, I understand what is the great exercise that these people have done. Organization of sovereignty within the Constitution. See, this sovereign power of the people of India should be infused, imbued into this document, the Constitution, which we hold in hand. How they have done? It starts with the opening words, we, the people of India. Who are we? You and me are there in that we. These people are also there in that we. Those people in the Constituent Assembly, those people who were living at that time, and for all generations to come in this country are we the people of India. We have created this document. We are the sovereign people, no? We have created this document.
Yes.
Starting with this word, we the people of India, the last article of the Constitution, Article 395, they have repealed Independence of India Act and Government of India Act. So India gets independence when British Parliament passes a law, Independence of India Act. Okay, then Dominion of India comes into existence.
Yes.
So now that we are sovereign country, we repeal your law. You are a foreigner. If you can legislate about India, we will repeal that law. We are independent sovereign. So they have organized sovereignty in the Constitution. What is there? Sovereign power. And second, there is what is known as continued organization of sovereignty within the Constitution. This is very, very important. So Constitution making is a big exercise. 2 years, 11 months, 18 days is not a small time. Country cannot wait for that exercise. So a small amount of constitutive power will be infused into the Constitution so that the Constitution can adapt itself to the changing circumstances. See, I tell you, sir, average life of the Constitution in the world is 17 to 19 years. Okay. When average life of the Constitution is 17 to 19 years, what is the age of our Constitution? 75 plus. What makes this, see, Constitution of Sri Lanka, Constitution of China, USS, Russia, what is this? France. All these constitutions are younger to our constitution. Okay, they are all subsequent to Indian Constitution. See, Indian Constitution stands the scrutiny, answers the requirements because of this continued organization of the sovereignty within the Constitution by way of provision for amendment of the Constitution when it is required. See, Constitution is not a document to be worshipped. It is a document to be debated, challenged, implemented. These are the expressions in Neera Chanduke's book, We the People and the Constitution. Okay, so it has stood the test of the time because of this continued organization. Another important requirement of a complete constitution is tracing out the domain of liberty within the constitution by the sovereignty. You have fundamental rights. Okay, it is there, entrenched Bill of Rights, we say. If it is done through a ordinary law, another parliament will pass another law and that will be taken away. But these are there in the Constitution. They cannot be taken away, touched by any power. Okay. This is tracing out the domain of liberty. That is one of the very important aspects. Then, a provision for temporary suspension of liberty in times of war and public disorder. That is also there in our Constitution. Organization of the government within the Constitution. That is there in, see, it is a parliamentary form of government, it is organized. And guarantee or security against change of sovereignty except the power which is sovereign power. That is also there. So, our Constitution answers all the requirements of a complete Constitution because it is a complete Constitution. After Nehru, some other party came to power, no? Succession. Janata came to power. Janata Dal came to power. BJP came to power. Yes. See, whenever there is change in the government through electoral mandate, the power transition is smooth from one civilian government to another civilian government. It has happened in India. It has not happened in any of our neighborhood. Pakistan had to wait for 60 years to see that power will go from one elected government to another elected. 60 years. After 60 years, it happened. One elected government handed over power to another elected government. But in India, we do not have a problem. Why it is like this? It is like this because of that Constitution. Because of the Constitution. Military is subject to civil power in India. but somewhere else civil power is subject to military power. So this is not an ordinary constitution, and that's how it has catered to the needs of the country for 75 years. Okay. So there are problems, there are drawbacks in operationalization. It is not a machine which moves on its own. It requires somebody to move it. The one wonderful book, Indian Constitution, the Cornerstone of a Nation, written by an American historian, Granville Austin. Indian Constitution, the Cornerstone of a Nation. And he survived to watch the Indian Constitution in action for 50 years. When we celebrated Golden Jubilee of Indian Constitution, he came out another book, Working of a Democratic Constitution, wherein in the first book he writes, Indian Constitution is a social document. What is contemplated in the Indian Constitution is a sort of social revolution. And part 3 and part 4 of the Constitution speak in terms of social revolution. See, we call it a transformative one. So, to transform India from one form to another form. When we became independent, we were in one form. From this form, we have to go to another form wherein we have contemplated that this form will be sovereign democratic republic. Okay. And in the second book, what he writes is, this is not an ordinary experiment that has gone on. Okay. See, when you see long queues before polling booths, and last election, state elections, record-breaking, 90% polling.
Yeah.
Right? What faith that common man who stands in the long queue, that laborer, that working class, that carpenter has in that constitution, which makes him to go and stand in that queue to vote. For him, vote is participation in the governance. And that is the festival of democracy that goes on whenever elections are conducted here. They know they get nothing in return, but they feel it is their country, they have to vote, and this is the mandate which they are giving to the people. And nowadays, people are becoming very, very conscious. See, I was telling you, constitutional culture is very important. As a law teacher, I should know how to train my students. And for that, I should know how I have to behave and conduct myself. Legacy, we say he has left a legacy. What is leaving a legacy? Leaving a legacy is how you train your next generation is leaving the legacy. All those great eminent advocates, they have to leave a legacy. So if I confine my profession to earning, I will not leave a legacy. See, right now here in Bangalore, you have so many great officers wherein the just so and so is from this chamber, from this office. No?
Yes.
That is their legacy. So
Yes.
they have trained their juniors, wherein 5, 6 of them are sitting as honorable judges in the High Court and Supreme Court. No? So that is the legacy. We have to establish that constitutional culture. Every individual should feel that this is my document and I have to practice the values that are there pulsating in the Constitution. So it has served the country to a very... And another observation he makes here is very important. What is Constitution? Constitution is what is available to people. There may be so many things in the Constitution, but whether it is available to people is the question. Going back to that question of highly, pressed education, right?
Yes.
But courts are playing their roles. They are making free and compulsory education. Because of the court intervention, it has become a fundamental right. Positive content is poured into the negative rights. Things are happening, and courts have gone all out to preserve constitutionalism. But the journey continues. See, America, they had a doctrine, separate but equal doctrine, between blacks and whites. Blacks and whites are equal but separate. And this equal but separate doctrine ruled that country for more than 50 years. And that famous judgment of Justice Harlan becomes the law of the land after so many years, 50 years after the judgment, 80 years after the judgment, 50 years after his demise. He was so prognostic. Things like that happen. So that should be, these things should be available. So we celebrate that to be a great democracy with Statue of Liberty, oldest constitution, but they have done so many experiments. With the history of 230 years of the existence of the constitution, we are 75. We are very, very young in that. One more thing I have to mention, Palkhivala classifies democracy at 3 levels. Respect for the majority is the first level of democracy. Okay? And respect for minority is the second level of democracy.
Shouldn't be it other way around?
Respect for my first level, first party post, whoever who forms the, whoever who has numbers will form the government. First level of democracy. Whatever the margin, but I am majority, I form the government and you have to respect me because I form the government. As per the constitution, when democracy matures, protection of minority will become the hallmark. Minority, not minority in terms of religion or whatever it is, minority voice, constructive opposition. Any worthy government in power will consider the opinion of the other groups also in a democracy. Respect for minority is the second. So when government matures, when democracy matures, yes, you are not in power. I am voted to power. But you are also returned through electoral mandate. You are representing so many constituencies. Voice of those people also should be heard through you, your party, whatever it is. Okay? This is the second. And third level of democracy is respect for unenforceable principles. Highest level of democracy. And having said this, he says, in this scale, India is a toddler democracy, he writes, when he wrote it. See, these are the things. As the country progresses, there will be developments, there will be change.
Got it.
Lot of new things have to come in.
So, when I actually last time met you, you told one interesting thing which caught my attention.